Good afternoon, and thank you for joining us today for the annual Ralph F. Fuchs Lecture. The Fuchs Lecture in Law was established in 1993 to honor the memory of Professor Ralph Fuchs, a distinguished and respected member of our faculty from 1945 until his death in 1985. Professor Fuchs was an accomplished teacher and scholar and a pioneering scholar in the area of administrative law. But he was equally well known for his lifelong commitment to public service and for the dedication, creativity, and compassion he brought to that work. He was the first chairman of the executive board of the Indiana Civil Liberties Union. He was active in the NAACP and was appointed to its state committee on legal redress. He was also deeply committed to defending the rights of free speech, free press, and free assembly in the university context, eventually becoming the president of the American Association of University Professors. Past Fuchs lectures have included some of the nation's top lawyers and legal scholars, all with a deep commitment to public service. They include Morris Dees, civil rights lawyer and co-founder of the Southern Poverty Law Center; Elliot Milstein, professor of law at the Washington College of Law and past president of the American Association of Law Schools; Jerry Chang, a vice chancellor and professor of law at UCLA; Professor Letty Volp from UC Berkeley Law; Professor Tracy Mears from Yale Law School; and last year, Lee learned from the ACLU's Immigrant Rights Project in New York. It is an honor today to be able to add to that distinguished speakers list Professor Bob Chang, who is the professor of law and the executive director of the Fred T. Korematsu Center for Law and Equality at Seattle University's School of Law. Professor Chang has a distinguished career. In addition to serving on Seattle's faculty, he previously served as their Associate Dean for Research and for Faculty Development. Prior to that, he was a professor of law and the J. Rex Dibble Fellow at Loyola Law School in Los Angeles. He holds a BA from Princeton and a master's and a JD degree from Duke. A prolific author, he has written several books and more than 50 articles, essays, and chapters. And he has been widely recognized both for his scholarship and for his service to the profession. He has the distinction of being the 2009 co-recipient of the Clyde Ferguson Award, granted to an outstanding law teacher in the course of his or her career who has achieved excellence in the areas of public service, teaching, and scholarship. He's also the co-recipient of the 2014 Charles A. Goldmark Distinguished Service Award from the Legal Foundation of Washington for his leadership role in the statewide task force on race and the criminal justice system. This year, he was recognized with the 2018 M. Shannara Gilbert Human Rights Award from the Society of American Law Teachers, and he became an elected member of the American Law Institute in 2012. Most importantly, Professor Chang founded the Korematsu Center, and through that role, he has worked with students in his civil rights clinic on some of the most important cases in the nation. He's served as co-counsel representing high school students in Tucson who challenged the constitutionality of an Arizona statute that resulted in the termination of the Mexican American Studies program there. He's also serving as co-counsel in two cases in Alaska, challenging involuntary psychiatric hospitalization of Native foster children. The Korematsu Center has also been active filing amicus briefs in the Muslim travel ban cases and the rescission of the DACA cases. Please join me in a very warm welcome for Professor Bob Chang.
Thank you, Dean Parrish, for the generous introduction. And so also thank you for inviting me to give this lecture. And also thanks to Professor Wang for inviting me today. So today I'm going to do three things. I'm going to place the travel ban in historical and doctrinal context. And I'm going to talk about what was at stake in the litigation, concepts that might be described as immigration exceptionalism and national security exceptionalism. And then finally, I hope to end with a few thoughts about what's next. So anyway, this summer, after a year and a half of just crazy stuff going on in the courts, and crazy because for those who entered law school when the travel ban was first put into place, and you saw the litigation happen so quickly, law doesn't happen like that. If you think that's the way it happens, it doesn't happen like that. More typical is what happened in our Arizona case, where after 6 years, after a trip to the Ninth Circuit and back for trial, we finally get to go to trial and get a resolution. And so that's more typical. Things happening this quickly, it's really quite remarkable. One of the things this summer, and I hesitate sometimes to use the term fake news because I think that's a dangerous phrase. But I guess at the same time, there's something fun about calling something like Korematsu versus the United States Overruled and describing it as fake news, because I really do think of it as fake news. After the Supreme Court decided the case, you might have seen in some legal publications and in some popular news outlets that Korematsu versus the United States was finally overruled. And you know, you have Justice Roberts, who wrote the opinion of the court, and he talks a little bit about the differences in terms of what was happening in the travel ban litigation, in the travel ban, and then comparing it to what happened during World War II. But then he ends, and this is the highlighted phrase at the bottom, where he states, Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and, to be clear, has no place in law under the Constitution. And I hope to problematize what he's saying there, and that's the thesis that I'm going to develop through this talk. Now, this view with regard to what happened in Trump versus Hawaii, as expressed by Chief Justice Roberts, may be contrasted with what Justice Sotomayor had to say about it. And what she says is that basically, although there was in some ways a formal repudiation of Korematsu versus the United States, what actually occurred was a reinstatement of the logic behind Korematsu, a facially neutral executive order, and facially valid. And then you had tremendous evidence, strong evidence with regard to animus that ends up being disregarded. And then you get the conclusion that's there. And so in some ways, Justice Sotomayor views Trump versus Hawaii as a very dangerous case. So in some ways, Korematsu has been replaced. I mean, the thing about it is that I think it's super dangerous because Korematsu was kryptonite. You couldn't cite to it. So what happened actually was that litigants who wanted to rely on the principles in Korematsu would actually cite to other cases citing Korematsu, and they would hide it. And I wrote an article called Whitewashing Precedent, and I actually saw it in the government briefs in this litigation. So they would cite to it, and sometimes they would play it cute, and they would have a parenthetical that would say citation omitted. Well, and it wasn't. And those weren't actually, the citation in some of those cases wasn't directly Korematsu, but it was another case that then eventually led you back to Korematsu. And that's a dangerous thing, this sort of form of whitewashing. And I think that's also what ends up happening with regard to Trump versus Hawaii. But let's start back at the beginning. So January 28th, 2017, this is a picture of SeaTac Airport. And similarly, in Indianapolis, I don't know if it was on the 28th or the 29th. The news article was the 29th from the paper that I got it from. But this is Indianapolis Airport. I don't know if some of you were there. I don't know if some of the professors were there. I don't know if some lawyers were there. But you saw this tremendous outpouring of protest when it occurred, because it was this remarkable thing that happened. You had somebody like Hamid Khalid Darwish. He's somebody who had worked for the US military from 2003 for approximately 10 years. First directly for the 101st Battalion, and then eventually for government contractors that were working for the United States. Because of his involvement supporting the US efforts in Iraq, his family was threatened, so he actually had to move a couple times. And so 2 years before he came to the United States, he applied for what's called a special immigrant visa. And so you think about this, 2 years of vetting. It took 2 years for him after all of this to supply all the paperwork, to have the review. And finally, he gets what I describe as a golden ticket, the special immigrant visa. And he also gets it for his family. And so he's on the plane. He actually arrives, I think, and within the hour after Trump issues his travel ban, and he's stopped. He's held at JFK Airport. For reasons that are unknown, his family is allowed to enter the United States on the special immigrant visa, but he is held, and he is held overnight. Immediately after that, you get litigation that happens. And this is actually a picture of him after he is released. But as this was happening, I had this profound sense of deja vu. Like, I've been here before. And the being here before goes back to 1889. And so there was this man, Che Jianping. This is his re-entry certificate. So he's a Chinese laborer who came to the United States in 1875. He worked here for at least 12 years. And then he decided that he was going to go visit China. Now, the problem was that in 1882, the US Congress passed the first of a series of Exclusion Acts. So 1882 was the first Chinese Exclusion Act. It was amended in 1884, and then again in 1888, 1892, and so on from there. And so what happened was that for those laborers who were lawfully present, who wanted to visit China, and you can imagine why he might want to visit China. Many of the laborers here had family there. Sometimes they had wives, children that they wanted to visit. And so this is what he wanted to do. Now, he followed the rules. He got this of reentry. This was the ticket for him to get back. So he went to China, and then on September 8th or 7th, he boards a steamship Belgic in Hong Kong. And transportation technologies being what they were, it's a little different from what happened to Hamid Darwish, where he's gets on the plane and he has the special immigrant visa ticket. So Che Jianping had this reentry certificate, and then on October 1st, there is the promulgation of this amendment where Congress decides that all of the previously issued certificates of reentry are no longer valid. And so he arrives in San Francisco on October 8th, presents his certificate, just like Darwish. And the harbor master there says, well, they passed a law while you were on that steamship Belgic from Hong Kong, and you can no longer re-enter this country. So we've been here before, but he takes this challenge to the US Supreme Court. And you might wonder, how is it that a Chinese laborer is able to take a case in 1889 to the US Supreme Court? And what happened was that because of a series of anti-immigrant legislation, first at the local level in California, and then at the national level, you actually had a very organized legal effort, and you had the various family associations fund attorneys. And there was an op-ed one time that was complaining that the Chinese fight unfair in the courts. And the reason that the Chinese fight unfair in the courts is that they hire the best legal talent. So this is how his case ended up being at the US Supreme Court. Now, when this case came before the US Supreme Court, I described this as, in some ways, a fork in the road. So previously in con law and in civics classes, you learn about Marbury versus Madison. You learn about this grand tradition of the checks and balances, the co-equal branches of government, and this idea, in some ways, the judicial power of the United States is extended to all cases arising under the Constitution. That's the grand narrative. The other grand narrative that you're usually taught is this notion, in some ways, that what we have is a self-correcting mechanism. So even if there are defects, that progress, we will eventually fix the errors that might have been part of where we began. And so then the United States Supreme Court had to decide, well, what do we do with this in Che Jianping's case? What do we do in Che Jianping's circumstance? And it decides to set aside immigration matters outside of the normal way that we would think about constitutional jurisprudence. So if Congress decides that there is a race that will not assimilate with us, if Congress decides that it is detrimental to the best interests of the United States, then it may decide to keep them out. And not just make Congress do that, but what is the role of the judiciary? And this is at the very bottom. This determination is conclusive upon the judiciary. And so from this, we get this idea or notion of the plenary power doctrine, this idea of immigration exceptionalism, that with regard to matters regarding the border, the things that we, sort of take for granted in terms of the role of the courts, well, that gets set aside. I think it's a tremendous disservice that most con law courses don't teach the plenary power doctrine. Although it's quite possible after Trump versus Hawaii, maybe they will start teaching it because it actually underlies, what's going on in that particular case. Now, if we think about the language that is used in Che Jianping, there's language about the Oriental invasion, this great danger, the West being overrun by the Chinese, dangerous to its peace and security. I mean, the other thing that also happens as the course of the various litigation around Chinese exclusion and Asian exclusion, you also start to see a shift. So initially, matters regarding immigration were thought to be within the sort of the realm of commerce. and it was the Secretary of Commerce. But at a certain point in time, it becomes the Secretary of State. And so what changes then is that immigration, border, becomes national security. And so that's where immigration and national security really do come together. Because you see this, it's this threat of peril that requires, in some ways, that Congress be free to act, and free to act without judicial intervention. And so then, as this progresses, for those residents who were lawfully here, well, law was passed that required them to have certificates that said they were lawfully here. Now, one of the limitations for this was that you needed one credible white witness. There was a test case that was brought right away, and the three men, they lost in a case that went up to the US Supreme Court. Now, this case, I think also, well, actually, no, it's the next one. So this starts to reinforce this notion that Congress can do whatever it wants, and the judiciary really has no say with regard to it. From this, we start to get what you might have seen in the travel ban litigation discussion of consular non-reviewability. It's this idea that a foreign consul in a different country says, I'm not going to issue you a visa, that determination is outside of any judicial review. But the root of consular non-reviewability actually comes from domestic actions. So the Immigration Act of 1891 really started, in some ways, federalizing the immigration system. Before, it was this interplay between local and state authorities and the federal government, but then it starts to shift. It's really the bureaucracy of what we think of now as ICE. It really starts there. And also, it's also the rise of the administrative state around this time. And it's centered around control over bodies marked by difference. And so you get a couple cases. I want to just focus on United States versus Zhu Toy. So Zhu Toy comes to the United States. Well, actually, he returns to the United States. And when he comes, he says, you have to let me in because I'm a US citizen. Wong Kim Mark, I was born here, I'm a US citizen. The immigration officials didn't believe him. And the appeal was carried at that time to the Secretary of Commerce, and the Secretary of Commerce said, well, I agree with that. He was actually able to get a habeas petition, and a federal district court judge, a US federal district court judge, believed him. He believed Zhu Toy had been born in this country, was a United States, and was being unlawfully excluded. Case went up to the US Supreme Court, and the court decided that because the 1891 provision provided the review process, discretion lies with the local officer, and the pathway for appealing it stopped at the Secretary of Commerce. They treated it as a jurisdiction stripping mechanism that said federal courts have no say. And so you have this man who a federal district court judge has said, this is a US citizen. And guess what happens to Zhu Toy after the United States Supreme Court decides? He gets banished. Scott Brewer, justice at the time, wrote this blistering dissent. In some ways, we start to see his views start to mark some changes, start to be recognized over time. This Zhu Toy case, I think, is also of tremendous current day relevance because of what's happening in Texas. I don't know if you've been following, but a number of persons in certain counties in South Texas who were born, who have birth certificates, are being denied passports or renewals of passports. And it's based on this idea that, well, prove it. This document apparently isn't enough, and it'll be interesting to see how this ends up playing out. Now, so far, it's really been a story about what Congress has done, but then you start to see a shift in terms of Congress giving this power to the executive. And so in 1907, Congress says, whenever the president shall be satisfied that certain passports issued are going to be detrimental to the national interest, that the president may bar the entry. And so a couple months after that, Teddy Roosevelt issues what I think is the first travel ban executive order, Executive Order 589. And he decides that Koreans are going to Hawaii and Canada and Mexico, and then they're coming into the United States. They're sort of circumventing what the agreement that he had entered into with Japan, where Japan was going to stop issuing visas for Japanese laborers. And so he decides, well, we're going to stop them. This shift in terms of the power of Congress to the executive becomes relevant, especially in terms of how it plays out with regard to the travel ban. The authority with which or under which President Trump issues the travel ban, it's because of an explicit authorization by Congress. Congress has given the authority recognized in the Chinese exclusion era cases to the executive, and then the executive acts. And so then the question is, how does that play out in terms of judicial review? It was funny going back to this, doing research on this. I was like, when I came across it, it was like, oh, who's written about it? So I put into Westlaw, Executive Order 589, and I think one person has written about it. It's like, I get excited because I'm going to learn about this. Turns out it was me back in 1993. So I don't know what that means, but now, I've been talking about immigration exceptionalism and connecting it up to this idea of national security. We start to see in some ways a sort of more stark version or form of national security exceptionalism with the advent of World War II. And we have President Roosevelt signing Executive Order 9066. In some ways, it was facially neutral. It didn't say the Japanese or the Germans or the Italians. It was facially neutral. But it authorized the Secretary of War and commanders to decide, from which any or all persons may be excluded, and within which the right of any person to enter, remain in, or leave may be restricted. And then Congress made it a federal crime. In some ways, this was a blank check that was given to the military commanders. You get Lieutenant General John DeWitt, who is in charge of the Western region, and he issues Civilian Exclusion Order number 1. The first one affected Bainbridge Island up in Washington. And also, I think it's very important to humanize things. Sometimes when we do law, we just deal with abstractions. Real people. These are residents of Bainbridge Island getting on a ferry boat. Most of them ended up at Minidoka. Here, I love this picture because of the ironic placement of the United States flag in this incarceration camp. And I compare that though with Ansel Adams, and I'm pretty sure, I don't know who took that picture, but I'm pretty sure it's not Ansel Adams because that's Ansel Adams, right? You can tell the difference there. Ansel Adams in 1943 and 1944 made a series of trips to visit Manzanar, and he documented through photos. He also published in 1944 a book, Born Free and Unequal. Remarkable, remarkable photo montage, also accompanied by text. Really, really wonderful if you get a chance to look at it. It's funny because if you use your arm and sort of block out the barracks or the living quarters, you see, what you normally think of as Ansel Adams, but really remarkable, that book. Now, you also have to think about the effect on children. This is a Japanese American girl who is either getting ready to go to an assembly center that preceded going to one of the incarceration camps. The assembly centers were often fairgrounds, sort of state fairgrounds, and often they were put into horse stalls that were converted. Now, this came up last year because Walmart was selling posters of this. You could buy this, and I think it's great to remember the past, but I was a little troubled by the way that they were commodifying it. They described it as the perfect wall art for any home, bedroom, playroom, classroom, dorm room, or office workspace. And I just wonder sometimes, what they were thinking about when they decided to sell it in this way. Clearly, I'm pretty sure they didn't have the context. And then when it was brought to them that this was actually a photo of a girl being taken to one of the incarceration camps, they stopped selling it in this way. So, with the various actions that were taken, so you had exclusion. You also had, starting at the curfew, Japanese Americans were required to abide by a curfew. Minoru Yasui, who's on your right, was a Japanese American attorney who graduated from the University of Oregon. When the curfew order came out, he decided he was going to challenge it. He wanted to be a test case. On Friday evening, after the curfew was in place, he was walking around the streets of Portland trying to get arrested. And one police officer said, "Go home, you're going to get in trouble." So finally, he presented himself to the station house, and he explained, like, "Look, I'm Japanese American. I'm not supposed to be out on the streets. I'm out on the streets. You're supposed to arrest me." And they obliged him. Later on, he tells a story that he regrets having done it on Friday evening, because the problem with Friday evening is that arraignment isn't until Monday. And so he was stuck there all weekend. And he said, it was most of the people who get put in there over the weekend, they were for the drunk tank. And so he was kind of stuck there. Gordon Hirabayashi was a student at the University of Washington, and he violated both the curfew and also the exclusion order. They took their test cases up. In some ways, because Minoru Yasui was just testing curfew, Gordon Hirabayashi was testing exclusion, but the FBI, when they went through his diaries, noticed that he had also been violating the curfew. So he was convicted on 2 counts, violating the curfew and violating exclusion. And then the US Supreme Court, in deciding this case, decided, we don't want to get to exclusion. That's a tougher question for us. They thought in some ways curfew was a lesser limitation in terms of civil liberties, and maybe that's just what we need to tolerate in times of war. So they just reached the curfew issue. Now, in their decision upholding that military order with regard to the curfew, I described it in some ways as the death of irony. The US Supreme Court, and this is Chief Justice Stone writing the opinion. This same Chief Justice Stone who wrote footnote 4 in Caroline Products, the sort of birth of what you need to do with regard to discrete insular minorities. He just sort of forgot this, I think, when he was deciding this case. But Chief Justice Stone talked about how, in some ways, well, we can't trust Japanese Americans. We don't know enough about them. And there was this footnote that talked about the history of discrimination against Japanese Americans, sort of this litany of things. We don't let them become naturalized citizens. We keep them from certain occupations. We subject them to miscegenation laws. In some states, we put them into separate schools. And so this litany, or the point about the discrimination, was, we need to discriminate against them now because we discriminated against them in the past. It was the past discrimination that made them not trust Japanese Americans, because it was funny, they in some ways were making it rational. It would be rational in some ways for the Japanese Americans to be against the United States government because we mistreated them. So you really need to be careful about this, but I described that in some ways as the death of irony. Fred Korematsu, this is a picture of him at a young age. This is much later in time. He takes this case up to the US Supreme Court, and they have to reach the question of exclusion. His attorneys also want them to address incarceration, the placement in those incarceration camps. But they sort of avoid that. They want to do it on as narrow a ground as they can. And in a decision written by Justice Black, they uphold the exclusion order. There were dissents in that case, and if time permitting, I'll talk a little bit about those. Now, when the travel ban litigation started, at first, I felt very helpless. I don't know, how others were feeling. I saw attorneys going to the airports, but even though I do civil rights work, I don't do immigration law. I don't do that. And in some ways was feeling powerless. But then when I started to see the US government's arguments being put forward to defend the travel ban, it was like, oh, we need to talk about the Chinese exclusion era cases because that's the plenary power doctrine, because this is about immigration. And we also need to be talking about Korematsu. And so we began filing briefs in all of the courts around the state. It's all around the country. It's funny, the things that you learn. So if you file with a particular judge, I won't name the judge in California in the Central District, in addition to doing the electronic filing, you have to do a courtesy copy to his chambers that is 2-hole punched at the top. of the document. And if you don't, you're going to get dinged for a defective filing. The lesson in part with that, a lot of times you learn about the rules of procedure. Well, learn also that in addition to the federal rules of civil procedure, the courts have local rules. And then on top of that, there are chamber rules. And so when you're acting before any judge, make sure to go do all of that because you don't want to get a defective filing. You know, they'll usually give you a chance to fix it, but it doesn't feel good. I've had defective filings, by the way, so I'm not, and you know, so in one of the Second Circuit rescission of docket cases, they're up to like document number 500 something. I think 300 of them are defective and repeat filing, people trying to fix the documents. And they're getting dinged because, I don't know, so, you know, I'm really good at Word, and so I'll be able to have the table of contents be Roman numerals and then different page numbers for the body of the brief. But the Second Circuit clerk there is such a stickler that you need to go into the full Adobe the program, and you need to tell Adobe that those Roman numerals are Roman numerals. So very, very strange. Completely irrelevant. But we filed around the country, and it was very crowded. But in the beginning, they weren't talking about Korematsu. They weren't talking about the Chinese era exclusion cases. But then finally, and this is the second executive order, you have Judge Richard Paez asked directly about Korematsu. The week before, Judge Wynn in the Fourth Circuit had sort of mused aloud about it. And the other thing about it is when you do amicus work is you never know whether you're going to have an impact. And so it was so exciting when Judge Paez says, you know, I have this brief from the Korematsu Center. So that was nice. Validation that, you know, you're not just throwing them into some electronic void. And so Solicitor General Wall says this case is not Korematsu, and I wouldn't be here if it were anywhere near Korematsu. So he says this is not like this. You get, now with regard to Travel Ban 3, and this is before Judge Chang in the Eastern District of Maryland. And in this case, Judge Chang asked, how is this different from Korematsu? And then this is the killer question at the bottom. Are you representing to me now as an officer of the court that there's nothing in there that is inconsistent with that proclamation? So then you're thinking this goes to what, RPC 3.3, right? Candor to the tribunal. Now, this came up and we were very clear in presenting our story to the courts that there was a problem with regard to candor in the litigation in Korematsu. And so it's remarkable where there were some attorneys in the Department of Justice that said, you know, we really need to have this long footnote that says that certain intelligence agencies found that there was no threat from Japanese Americans in US territory. We need to have this footnote. And they drafted this footnote. And it comes back to them way edited down, and it doesn't include that information. There was information that was withheld from the US Supreme Court. And I think that's where we need to think a little bit about what was going on in the travel ban litigation, whether the attorneys actually were candid before the court in presenting all of the evidence, especially when we find out later that the months-long multi-agency review produced a 17-page report. That was it. That was the thin record that they based it on. And the other thin record, the other part of it was that the Department of Justice refused to let the judges see it. The Fourth Circuit said, we want to see this. And the Department of Justice said, no thanks, we're not going to show it to you. It'll be interesting to see what history shows us, whether or not we're going to find out, as we did in the Korematsu instance 40 years later, things in the archives that show the information really wasn't as it was presented. Now, trying to be a little bit mindful of time, I think I was told about 30 minutes, I'll probably go 35. So when we think about Korematsu versus the United States and Hawaii versus Trump, in some ways, you know, I'm still working on this slide, just sort of this comparison. Now, in each instance, you had a facially neutral executive order. You had this notion that the actions taken were within the authority of the executive, the president, and the president then granting it to military commanders. You had, in each instance, strong evidence with regard to animus. And so then the question is, what do you do with that? In Trump versus Hawaii, Justice Roberts acknowledged a number of those comments that were made by candidate and President Trump, but then he says, it's not our responsibility to denounce these statements. And Justice Sotomayor actually agrees with him on that. And that's actually right. It's like, that's not the role of the courts. They're not there to denounce the statements, but they are there to safeguard the Constitution. They are there to decide that if the actions taken by the executive are improperly infected by bias, that actually is a constitutional violation over which the courts have the jurisdiction and the ability to review robustly, and also in certain instances to declare them invalid. But in each instance, you had a failure of the courts to do that. Partly, maybe because evidence wasn't fully presented to the courts, but partly because in some ways this was the result that the majority wanted to reach in Trump versus Hawaii. And so the most dangerous statement, though, I think was actually in Justice Kennedy's concurrence. And in Justice Kennedy's concurrence, and I should have put ellipses there, there's some paragraphs before this, but he talks about how there are numerous instances when there might be actions undertaken by government officials that are outside of judicial review. When you see a statement like that, you should just, wow, right? And I know there's the political question doctrine and things like that, but that's a remarkable acknowledgement of the judiciary stepping to the side. And then what he leaves us with is hope and faith. In some ways, this idea, indeed, the very fact that an official may have broad discretion free from judicial scrutiny, makes it all the more imperative for him or her to adhere to the Constitution and to its meanings and its promise. But the thing about it is, what is the role of the courts? And Justice Kennedy sort of accepts that's not for us. And so we have to have some faith in our officials to abide by the Constitution. And in some ways, that's where electoral politics becomes super important, especially when the courts may not be stepping up to their task. What I find really interesting is that in the litigation below, in all of the courts below, the courts were doing their job. That's why it was Trump appealing these cases. They were doing their job. You get this reversal up at the US Supreme Court. How's it going to end? I don't think it's over. So, and maybe that's just hope on my part. This is a button from the Truman Show. It's one of my favorite movies. It's about a reality TV show. So there's this guy who lives his entire life in a bubble. And it's a show centered around him. Now, the problem sometimes, and the point that this button was trying to make with regard to viewers was, well, with regard to how's it going to end? Well, you can approach this all as simply an observer. It's like, oh, and it's riveting, right? This drama that we see. But the thing to remember about all of this is that it's not just a reality TV show. We are all actors within this. We are able, if we see something wrong, to say this is wrong. We are able to develop the tools with regard to doctrine, with regard to the training, to then go out and do this work. And sometimes students ask, well, you know, it's like, how do I get involved in a case? Well, you show up. And it's remarkable what happens when you show up. And sometimes they're going to say, well, we don't need your help. But there are going to be times when they do need your help. You get to be part of it, and you get to learn and grow from that, and then also to teach others about this. Because this result, so Mr. Al-Shawi was also caught up that same day as Mr. Darwish. And it was the work of clinic students at Yale who successfully got a TRO that released him. And so he had been stuck in Germany in a refugee camp for a while. His wife and child were in the United States. His wife had worked for the US government for a number of years. This is the reunion with his child in Dallas. And so that's what being part of it and working, showing up can do. because we need more moments like this instead of moments like this. And so with that, I will stop. And so now we're moving to Q&A. And so I believe there is going to be one student running around with a mic. If you have a question, please raise your hand. Okay, I'll just repeat the question. So.
Thank you so much for coming to speak with us. Do you think that there could be any congressional reaction, like amending the Non-Reviewability Act, that could serve as kind of like a bottleneck for this to continue?
Sure. So because of our system of government, Congress may certainly act. Whether they will or not, it's unclear. So there's precedent, of course, for Congress deciding, for example, that a U.S. Supreme Court decision is incorrect. So as an example of that, in the late 1980s, there's this case Ward's Cove that challenged practices in canneries up in Alaska. And it was based on a disparate impact theory. And the U.S. Supreme Court said, oh, we don't really care about Griggs versus Duke Power. That was a U.S. Supreme Court case. The text of Title VII does not allow for disparate impact. So they got rid of disparate impact. And then in 1991, the Civil Rights Act, Congress said, we're going to write in disparate impact into the statute. And then it was signed by President H.W. Bush. So it doesn't necessarily come from just a Democratic president or a Democratic administration. But it depends on its politics at that point. And I think that's where I think it's really important not to let go of that dimension to it. So yes, things could change, but whether there's the will, that I don't know. Yes.
I can talk really loudly as well. So I know that in the last executive order left a loophole for special evaluation on an individual basis, but studies have shown that that's not happening, that they aren't that Homeland Security and immigration officials are not doing that individualized basis for applicants who would be applied to. Are there any potential for challenges of that to make it where they will start doing that?
So the question from the audience was asking about the waiver provision in the executive order. So in the last executive order, and maybe also in the previous ones, there was a way for individualized determinations to be made. Justice Roberts made much of the waiver provision to say, it's really not a Muslim ban because you allow people to go through this waiver process. It was interesting, Justice Baier, in his dissenting opinion in Trump versus Hawaii, presented, well, let's look at the facts. And at that point in time, the facts were pretty stark, showing, well, really, they're not really granting these. And I think since then, there's more evidence, and maybe that's what you're pointing out. I believe, so there may actually be a lawsuit that is challenging the improper application of the waiver provision. But it's interesting, jurisprudentially, that was very important to Justice Roberts. See, it's not a ban. It's really about security. And when security is not jeopardized, we let them in. He accepted it, even though the facts, even at that time, I think spoke against that. But I believe there is a challenge based on that. There are also challenges, I think, based on what's happened with regard to refugee admissions, which I don't think is part of the last executive order. If you were wondering why the third one was by proclamation, it's because the government lawyers finally saw, oh, the immigration provision that we're relying on actually talks about the president doing it by proclamation. And so that's why the third one is a proclamation. It's funny, when the proclamation came out, I was like, oh, maybe this is great because they did it wrong, right? They didn't do it as an executive order. And then I started thinking a little bit. It's like, oh, but the Emancipation Proclamation, I sort of want that to have legal effect. And so it turns out that they're treated interchangeably, and it's because of the specific statutory basis in 1182F that led them to do it by proclamation.
Did I follow correctly the thread from Xi Jinping down to what's happening in Texas right now? That there are persons holding documents that say they are United States citizens whose citizenship is being challenged by the government, and that somehow the mix of plenary authority, immigration exceptionalism, and national security exceptionalism, they allow the government to keep those persons who, because for everybody else, we think of our passport or our birth certificate as presumptive evidence of our citizenship. For some classes of persons, that may no longer be presumptive evidence of citizenship.
So the question related to connecting up the Asian exclusionary cases with regard to what's happening in Texas and the challenges to citizenship based on their birth certificates, which they present, and which the State Department says, well, we want more evidence. So it is relevant, I think, in part because the processes that are put into place are going to be determined by Congress and then also the particular agency. And so what I see happening is a flipping of the presumption. So you talked about it as, well, we think of these as presumptively proving it, and then it would be for the government to disprove it, right? That to me makes sense. And I can think of lots of cases that would support that. But if they decide that, if the agency decides that the presumption is properly flipped, then on what basis can that be challenged? And so then it becomes a question of, well, sure, the agency's decision. I think that's where it would start. So if they flip the presumption and they do it based on the authority that Congress has granted to the executive is in charge of the Department of Homeland Security, under which that particular department exists, that presents very difficult doctrinal barriers to winning that case. So then you would have to, so then for those of you who have not taken administrative law, you need to take administrative law. I mean, so I don't know if it's required here. It's not at my school, but I tell all my students to take it. So much occurs in the administrative system. I mean, the civics book should be changed. There are four legs to the stool. The administrative branch really is one, although maybe you say, oh, it's under the executive, but I don't know. But you would pursue an Administrative Procedure Act, and then you probably would try to bring in an equal protection claim, also based on that. But then it's going to turn on the specific facts. What are you going to be able to prove? It's fascinating what's going on in the citizenship question case, the census citizenship question case, and all of the government officials that they're trying to not allow to be deposed. We were almost going to bring our own challenge. So we'd gotten Norman Mineta, who's the former Commerce Secretary, and we wanted him to be the lead plaintiff suing the sitting Commerce Secretary for this question. But there are some challenges with regard to standing in that case. But it's fascinating how hard the DOJ is working to keep information from the litigants and from the courts. Yes.
Sure. One thing that's striking, lurking behind kind of both societal movements, is rampant racism and xenophobia against particular groups in society. And what's interesting is the extent to which the court can sometimes play a role in providing a barrier or limiting the societal xenophobia to actually have a legal effect against particular groups. And in other instances, it seems like it provides a blank check or it allows it to go forward. So I'm wondering if, given that it doesn't seem to be driven by legal doctrine in the sense that you could create legal arguments on either side, whether you have something to say about the role of the judge and the way that judges should operate in society when there are social movements that might have be imbued with bigotry and xenophobia.
So doctrinally, one of the big challenges is the way that immigration exceptionalism and national security exceptionalism end up playing out, at least at the US Supreme Court level. You have the lower court judges looking at the evidence with regard to religious discrimination. You have in the rescission of DACA cases, the judges, except for the judge in Texas, the judges looking at the statements made by administration officials and candidate Trump and President Trump and saying, well, when you have this, we have to sort of tease out what role the improper animus may have played in the decision-making. Now, Trump versus Hawaii, I think, presents a tremendous danger because the Justice Roberts talks about the importance of looking at, well, this is an executive acting within the sort of zone of power that the executive has, and emphasizes the notion that it's a facially neutral provision. And it makes difficult or challenging the ability to reach into that. Now, what's, I think, disconcerting and maybe disingenuous about what Justice Roberts does in his opinion of the court in Trump versus Hawaii is to compare what the justices did a week earlier in Masterpiece Cake Shop. And in Masterpiece Cake Shop, when there was the emphasis made that there were two commissioners on the Civil Rights Commission that at an earlier proceeding had made remarks that could be seen as not being sufficiently respectful of Jack Baker's sincerely held religious beliefs. That even though every proceeding after that was de novo, the justices said, well, you have that. It infected the process. And the only way to address this is you send it back. But then, so when that came out, I was like, oh, maybe it's going to be 5-4 for the team that I was supporting, that they were going to make much of those statements. There's a disconnect, and I'm not sure how it's going to resolve. In some ways, there's a real danger in terms of the playbook with regard to what happened in Trump versus Hawaii, because, oh, the first time you screw up, you just do it again, EO2. Oh, that gets held up, you do EO3, the proclamation. You see it happening with the rescission of DACA cases. You have the original rescission of DACA memo in September 5 of 2017. And then that gets held up. And then there's a second chance. They do a new memo. And the district court judge in DC said, you know, still not good enough. They can go back again. And so the difficulty is, what is the connection then between the animus that might have been improperly part of the earlier decisions, and what if you're able to have a multi-agency, months-long review that produces a thin 17-page report? Well, Justice Roberts says, that's how you do it. And that to me is really dangerous. And so I remain hopeful in terms of the ability of courts and judges to step in. In certain doctrinal areas, I think it becomes more difficult. And then how it plays out. You know, I see coming up with the changes in terms of the judiciary, we're going to see much more the collision between disparate impact and disparate treatment. You might see it in the context of the litigation around affirmative action at Harvard or North Carolina. Now, the other thing about it is that we've been thinking in the Korematsu Center for some years about emphasizing state constitutional litigation as pathways, recognizing there are changes in terms of the court. And in a week, I'm giving a talk that's Justice Brennan was right. So in 1977, he wrote an article in the Harvard Law Review that talked about the importance of state constitutions in protecting individual rights. So Justice Brennan saw that Nixon got 4 appointments to the US Supreme Court. He saw that there were changes in terms of the way that court was treating the civil rights gains under the Warren Court. And he said, you need to pay attention to state constitutions. And so that's the other message that I'm trying to get out to students, to law professors. Sometimes the challenge with regard to law schools and law professors is, for us, it's sort of the national game. It's like the state stuff, like who that's just, what happens in the state. But we forget sometimes how important, like the litigation that goes on in the superior courts and to the state Supreme Courts, how impactful it is in terms of the lived daily lives of the citizens. It can be, in some ways, less fulfilling, because if you win in a state Supreme Court, that only affects that jurisdiction. Whereas if you get the big win at the US Supreme Court, and if it's a big civil rights win, you've raised things. But in an era where we're starting to see the sort of protections go down in terms of civil rights, I would encourage professors and students to pay more attention to state constitutions. Not all state constitutions are going to be amenable to this kind of analysis. You need to look at each state and each state's history. But for those states that have this idea or robust sense of the importance of protecting individual state constitutional rights, you get those wins there. And then you get the US Supreme Court case where they start to see, the changes that are occurring, the direction of the change. And so it's a different pathway, but I'd encourage folks to think a little bit about that.
You can get it next. So I wanted to know what your thoughts were in general on Chevron deference, because the legislative branch kind of gave away the issue to the executive. How would this? I'm curious whether this would qualify under Chevron deference to the executive.
So I apologize, but that's above my pay grade.
Okay.
So I don't have an answer to that, but
Okay.
I will think about it, and I encourage you to ask your administrative law professor
Sure.
that question. It's an excellent question. I just don't have the expertise.
Sure. All right, here you go.
But it flows into the answer that you gave me to my question about flipping the presumption and whether the agency is entitled to flip the presumption on the citizenship question in the Texas case.
Sure.
I think we're out of time. Please join me. Come out afterwards. Please join me. Thanks.
Thank you.
Great, Bob.